Please be seated.
Your Honour, Commissioners, this is the Royal Commission's 54th case study. This public hearing will, Mr. O'Brien, coming back to you in case study 29. The Royal Commission found that it's a general practice of the Jehovah's Witness organisation in Australia not to report allegations of child sexual abuse to the police or other authorities unless required by law to do so. You're aware of that finding, of course.
I'm aware of the finding, but we have never had a practice of not reporting.
Well, Mr. O'Brien, we went through this on the previous occasion, so I don't want to spend time on it, but of the 1,006 cases, if I recall correctly, not one was reported by the Jehovah's Witnesses organisation.
Well, I think the point was brought out that hundreds were reported, not by the organisation, because the organisation doesn't report. That's left to the elders handling the case. They're the ones who take the matter to the authorities or encourage the parents.
The simple point is this, is it's your policy is to not report unless the law requires it. That's the policy, simply put, isn't it?
No, that's not the policy. If I could correct you again,
yes.
You excuse me for doing that. Our policy is if it's mandatory reporting, we report. If the child or other children are at risk because of a perpetrator, we will report. And thirdly, we will always inform the parents, or if it's an adult survivor, that they have the absolute right to report. So to suggest we have a policy of not reporting is quite inaccurate.
Well, you've qualified it in one respect then. You said you have a policy to not report unless you assess that a child is at risk of harm.
So we, referring to the elders in the congregation, not the organisation, and keeping in mind that even if there is no risk and it's not mandatory reporting, we still inform the parent or the survivor, if it's an adult, they have the absolute right to report, and we will support them if they do that.
Yes, but that's then a case of them reporting, not the elders or the organisation reporting, not so.
No, because the law allows it.
In relation to reporting where there's an assessment of harm, can you identify, just for ease of reference, where in the 3 documents that's reflected?
Yeah, again, if I could refer that
yes,
to Mr. Spinks, he's more expertise on that.
Sure. If I pause just momentarily. We mentioned previously that it has been our practice at the branch office to inform the elders on every occasion that if there's a risk to a child or other children, that the matter is to be reported to the police, and we've documented that policy in the child safeguarding policy of Jehovah's Witnesses in Australia. But it's also been documented by the legal department and by the service department in each case where we get a report that the elders and subsequently the parents are informed of that. And
yes, I understand, Mr. Spinks. I'm just asking you to assist to identify where in these documents that guide the service desk, that guide the elders and that guide the congregation, those are the 3 documents we're looking at.
Sure.
Where that's recorded.
So firstly, if I could, if you just give me a moment, thank you. Yep. So in the child safeguarding policy dated March 7.
Yes. So that's the one at tab 11, yes?
Yeah, that's correct. And point number 9. It says if congregation elders learn of a case of child abuse in which a child may still be at risk of harm, they will ensure that a report to the police or other appropriate authorities is made immediately.
Right. Thank you. Yes, and in the other documents?
So obviously in the publications which were tendered at the previous public hearing, our publications have been saying that for decades, that if a child's at risk, whatever the cost, that's the procedure that we followed. It's documented in the reports that the Service Department receives. It's documented in the legal department's documents, but we recognised that it needed to be also put into this safeguarding policy.
When the document says the elders learn of a case of child abuse, are we to understand that as learn of an allegation?
Correct.
Why doesn't it say that?
I think it's a good suggestion. It's a poor choice of words, but that's the reference is of an allegation.
You see 8 speaks and 7 speak in terms of allegation. There was no intention to have a different meaning, was there?
Again, the practice is clear, Your Honour, and I think that's testified to by the fact that in each case over recent years, as we've documented, the policy is significantly, or practice is significantly different to 30 years ago, but certainly each of the cases, for example, in the period prior to and subsequent to the public hearing, that's been documented in every instance.
And tell me this, if you receive an allegation of abuse and you initiate your processes, but you don't get a confession, but you get a very clear statement from the victim that you would rationally believe, but for the fact that you don't have a confession or 2 witnesses. I appreciate that you would tell the adult victim they can go to the police. But with the knowledge that you would have in that circumstance, do you have any understanding of the law that might require you to report to the police?
You mentioned there, if I could, Your Honour, an adult survivor?
Yeah.
Yes, and in every instance, and there was discussion, Your Honour, as you recall, in relation to 316 in New South Wales, and which has been extensively considered. So in each allegation, the responsibility of our legal department, regardless of whether it's a child or an adult, is to determine, firstly, is there a reporting requirement under law, and obviously that then supersedes any other consideration.
So in the circumstance I put to you, you would tell the police?
You mentioned an adult survivor, so I just may be confused.
Yeah, an adult survivor who comes to you and says, I've been abused, and it's pretty clear, but for the fact that you don't have a second witness, that this person's telling you the truth.
Your Honour, at the Commission, in the publications, Your Honour himself has said that some individuals, adults, choose not to report and recognise that...
No. What obligation do you think you have under law in that circumstance?
With an adult survivor, to comply with whatever mandatory reporting requirement there is, Your Honour, whether that be a specific mandatory reporting requirement or a 316 or similar. We're absolutely obligated to comply with that.
And you would comply with it?
Absolutely.
Well, I'll come to the legal guidelines shortly, but just getting back to this point. So you've identified in paragraph 9 of this 7 March document, but the fact of the matter is that, isn't it, and by all means I'm asking the question so you can show me if I've misread it or overlooked it. The other 2 documents, the one that guides service desks and the one that guides elders, don't have any statement to this effect. In other words, that a report should be made to the authorities if a child is considered to be at harm or at risk.
That's not clear, as clearly stated in those. It's not clearly stated in those documents. It's a valid point, and our reason for wanting it included in this one, and in fact, just in the last 2 weeks in a video conference, I raised the very same issue. You know, why have we all agreed to put it in the public document, which is great, but we need to retrospectively use the same expression in those 2 letters, and that absolutely has to happen.
Well, it's more than just a valid point. I mean, it's a very critical point, isn't it, that the policy which guides the service desk and the elders in the organisation in Australia is to not report to the authorities unless required to do so. I accept the caveat to encourage people to report or tell them they have a right to report themselves. I accept that caveat, but it's actually not a caveat that applies to the other one that Mr. O'Brien added, which was also if the child is at risk of harm.
That's incorrect. It's correct that it's not in the document, but the evidence, and we're happy to make that available to you, Mr. Stewart, the evidence shows that our practice has been to make that assessment in every situation.
Well, that may be the practice. My point is in relation to the policy, and it's not stated, and you would agree it should be revisited and addressed.
I've already raised it myself. I absolutely agree.
And in fact, the Royal Commission recommended, as you'll be aware, that the organisation should always report allegations of child sexual abuse to authorities where the complainant is still a minor at the time that the abuse comes to the attention of the organisation, or where there are others who may still be at risk at the hands of the alleged abuser. Now, you haven't adopted that recommendation. Can you explain why?
We have, with respect, Mr. Stewart, again, if it's documentation, that may be the case, but you're aware that each of the incidents that have been reported to us, whatever the seriousness of it, since the public hearing, have been reported to the police for the very reason that you raise.
Well, Mr. Spinks, the best evidence of what the policies are of the organisation is to look at the policy documents. And if it's not there, then it's not the policy. Wouldn't that be right?
With regard to documentation, that's correct, but with respect, Mr. Stewart, if you looked at the incidents that have been reported to Jehovah's Witnesses since the public hearing, each of those has been reported to the police. So with respect, the documentation part of it I totally agree with and have made that recommendation myself.
And Mr. Spinks, while the documents now make it clear that survivors or their parents should be told that they have, as it's put, an absolute right to report, it's not the policy to actually encourage them to report, is it?
I think that's, again, not correct, because as the reports on each matter that's been reported to us since the public hearing, both the legal department and the service department use the same expression that it is their absolute right to report, and the elders will fully support you in doing that.
Mr. O'Brien, I think the point that's being made is that it's one thing to have responded since we looked at you, another thing as to what you were doing in 5 years' time. You understand?
5 years future, Your Honour?
Unless intent is reflected clearly in your policy documents, there's a very good chance you'll just fall backwards. You understand?
The point is well taken, Your Honour. We've put it in the most recent document, and retrospectively it has to be adjusted in the other documents. I take that point.
Now, we discussed a moment ago your reporting obligations, even in relation to an adult victim. That's not referred to in this document either, is it?
That would be a matter for the legal department, Your Honour, because every state
It might
is...
be, but surely it's a matter for the policy document, isn't it? If that's the policy of the organisation, that's where you should find.
Could I ask you to repeat the specific point, Your Honour?
Yeah. The obligation to report where the law requires knowledge of an adult victim is not referred to in here.
With respect, Your Honour, the most recent document says in paragraph 5, it says
When you say the most recent document, I'm still looking at
the child safeguarding policy, paragraph 5, says that the elders will consult with the Australasia branch office of Jehovah's Witnesses and will comply with any relevant secular reporting laws. So the other documents...
So that's where it's to be found, isn't it?
if you just give me a moment, Gerard. So in the August 1, 2016 letter protecting minors from abuse, the letter to elders,
Tab 7.
Yeah.
paragraph 5 says legal considerations in some jurisdictions. Individuals who learn of an allegation of child abuse may be obligated by law to report the allegation to the secular authorities. And then paragraph 7 says the legal department will provide legal advice based on the facts and the applicable law. So in every case that is considered.
I'll leave Mr. Stewart to explore what that actually means.
Well, the lens through which one might explore that is to look at what the legal department guidelines say. Because the position now, just to recap, is when elders learn of an allegation of child sexual abuse, they to immediately phone the legal department. Is that right?
That's correct.
And the legal department will give advice on their legal obligations.
That's correct.
And then pass it on to the service department.
Yes, they also have some advice that they give in addition to the law, but in principle that's correct.
Right. And we called for, and we've been furnished with the guidelines that the legal department uses in fielding those calls. Is that right?
That's correct.
Yes. And so if we look at the one for New South Wales, for example, at tab 13, and perhaps before we even look at it, we can address some bigger pictures. I mean, there are differences in the legal requirements across the states and territories. Is that right?
Correct.
And it's a complex environment.
Very much so.
Would the Jehovah's Witnesses support national uniformity to the extent that can be achieved?
Absolutely.
Yes. Now, if one has a look at this guideline, which is headed Reporting Obligations in New South Wales, and then there are a number of standard points set out under the heading Taking Calls Concerning Abuse Matters. Do you see that?
Yes.
And as I understand it, those are general points set to apply across the states and territories, and then the more specific provisions are dealt with on the next page. Would that be right?
That appears to be correct, yes.
And in paragraph 7, it says, if the victim is still a child under 16, is he or she still in danger? In other words, this is a question that must be asked. If so, the service department will provide necessary direction to ensure the child's protection. Now, you see that it doesn't ask whether there's another child in danger.
I think, again, these are notes. I'm not in the legal department. These are the notes of the legal department, but I think the safeguarding policy uses the generic child, but I agree again that should say if a child is, or any child is still in danger. That's a good point.
And related to that is even if the victim at the time that the call is taken is an adult, it doesn't deal with the question of what to do if other children are still at home. So in other words, a 20-something, 30-something-year-old reports abuse by someone who's still in the congregation. The particular person's abuse occurred many, many years before, but that there are other children potentially at harm because of that abuser still being there.
to excuse my ignorance, I'm not a lawyer, Mr Stewart, but does the Act that supports this advice make that point? I'm not certain. This is only the legal advice is the point I'm making.
You're effectively making the point, which is this, is why do you legalise it all the time and rely always on what the law provides? Why do you as an organisation just not adopt the policy, as many other organisations do, of reporting as a matter of course if there are still children who might be in harm's way?
Again, with respect, Mr Stewart, that's a very isolated point. This is the specific legal advice that is given. When the call comes through to the service department, in every situation, that is the advice that's given. This is purely the legal requirement. So why do we legalise the matter? Because they're getting legal advice. When it comes through to the service department, then we assess this.
Mr Spinks, the trouble is you've taken us straight back to where we were. We were talking about the service department guidelines a minute ago, which doesn't have the kind of policy recorded that I'm speaking of, which is uniform reporting where there's any risk of harm. And you referred us to the legal obligations. Now we're on the legal obligations, you're referring us back to the service.
I think that's I respect that's how you're viewing it. If you want, could I clarify it again? Is that
well, let me put the question again.
Sure.
Why is it that the Jehovah's Witness organisation has not adopted a standard policy to report allegations of child sexual abuse to the authorities where there is still or an ongoing risk of harm to any child?
We do, Mr Stewart. If it needs to be better documented, this is simply an extract of the applicable legal advice. This has nothing to do with our spiritual process, our scriptural process in the service department.
Mr Spinks, when you say we do, what you mean to say is we do as a matter of practice report where a child might still be at risk. Is that what you mean to say?
Correct.
Yes, and I'm addressing this at the level of policy. Why do you not adopt it clearly in your policy that guides your service desk to report in all cases of allegations of child sexual abuse where there's a risk of a child still being at harm?
Again, we do, Mr Stewart, and we will put that in that document, and that has been the practice. It is the policy. We've put it in the most recent policy document, and it has to be added into the others.
Now, this legal landscape, and I understand that, if I'm not mistaken, that neither of you are lawyers, but the legal landscape is complex. You've agreed and accepted that. And there are distinctions between different types of reporting. There may be reporting where there's a risk of significant harm, perhaps with child protection authorities. There may be reportable conduct schemes, for example, to the Ombudsman, overseeing how organisations are themselves dealing with reports that are made. And there are also, like Section 316 of the Crimes Act in New South Wales, concealment offences where a serious offence has been committed or there's knowledge with regard to the commission of a serious offence and it's then an offence not to report that. So there are these different regimes. Has the Jehovah's Witness organisation in Australia taken a view as to what the best way of dealing with these matters in the law is, so that you are able to make submissions or recommendations to the Royal Commission as to what the commissions should be saying about these matters?
I think all along we have said that we would totally support a simplified mandatory reporting scheme that is uncomplicated for all organisations. We've repeatedly said that, and that is still our position.
And beyond that, you haven't looked at these different possibilities of, that I've mentioned to you?
I think we've made the point, if I could repeat what Mr O'Brien said earlier, we comply with mandatory reporting requirements, whether that's a specific one or there's an implication under law. I believe the folder that we provided for the tender bundle, we've simply got the